The room went still the moment he said it, not loud, not shouted, just dropped into the silence like it had weight. "You may be used to talking to people who scare easily, Your Honor," the young man said, chin lifted, one hand still resting on the defense table like he owned the wood. "But I'm a Harvard student, and if this hearing goes where I think it's going, there will be consequences for you too." At 9:12 on a gray Thursday morning in Providence Municipal Court, even the clerk stopped typing. Judge Frank Caprio didn't answer right away. He looked over his glasses, hands folded, expression flat in the way only experienced judges can manage when they've just heard something reckless and are deciding whether it came from panic, stupidity, or habit. Outside, rain tapped against the courthouse windows. Inside, the young man in the navy overcoat was still breathing hard, still trying to turn a parking case into a power contest. He had come in over what sounded minor, a citation, a disabled parking placard, a tow notice from Benefit Street, $85 on paper, nothing that should have become memorable. But the problem with people who mistake procedure for weakness is that they often keep talking long enough to expose what they were trying to hide. And in that courtroom, on that morning, what looked like one arrogant student trying to bully a local judge was about to widen into something much uglier, a pattern, a paper trail, and one official record that turned a smug performance into a documented act of fraud. This was never really about parking. It was about entitlement colliding with a courtroom that ran on facts, and once the record came in, the entire case changed shape. The student was 21, clean haircut, expensive watch, controlled voice with that rehearsed calm some people use when they think sounding polished is the same thing as sounding truthful. He identified himself as an economics major from Harvard, originally from Newton, Massachusetts. He said he had been in Providence for a networking dinner the night before. He said the car was registered to his family. He said the disabled placard hanging from the mirror had every right to be there. Then he added the part that told the room exactly who he thought he was. "I know how this works," he said. "Small courts pressure people into quick admissions. I'm not one of those people." Judge Caprio let him finish. The city solicitor then did something simple. He asked the clerk to read the basis of the citation into the record, not just parking in a disabled spot. Display of a canceled placard. Unauthorized use. Vehicle observed at 10:46 p.m., with no disabled occupant present. Officer's note: operator walked briskly from vehicle carrying gym bag, no mobility aid, no passenger. Placard number flagged in system. The student smiled when he heard it, and that smile was his first real mistake, because he didn't respond like someone wrongly accused. He responded like someone who thought the accusation was too small to matter. "That officer made assumptions," he said, "and if this court is going to criminalize students because they don't look disabled enough, that's a very different story." It was a clever line, designed for reaction, designed for sympathy, designed more than anything to put the judge on the defensive. It almost worked. Then Judge Caprio asked a quiet question. "Who was the placard issued to?" There was a pause. "My grandmother," the student said. "Was she in the vehicle?" "No, but..." "Was she in Providence that evening?" Another pause. Smaller this time. "No." That should have ended the argument right there. In most courtrooms it would have. Misuse of a disabled placard is not a debate club exercise. It is not a branding issue. It is not solved by vocabulary. But the student kept pressing. He said his family shared the vehicle. He said the placard had been in the car for years. He said no malicious intent existed. Then he made the second mistake that mattered even more than the first. He leaned forward and said, "If you're trying to make an example out of me because of where I go to school, that will not go unanswered." That was the moment the hearing stopped being ordinary, because Caprio didn't rise to it. He didn't scold him. He didn't trade prestige for prestige. He simply turned to the clerk and asked whether the registry response had been received in full. The clerk nodded, and just like that, a man who had tried to make the room focus on his status was about to be crushed by something with no ego at all: documentation. If you appreciate stories where power finally meets consequences, stay with me, because this is where the mask started slipping. The Registry of Motor Vehicles had sent over a certified placard history. One page, state seal, issuance date, renewal date, cancellation code, associated beneficiary. The placard had belonged to his grandmother, yes, and it had been voided 11 months earlier. Not suspended, not pending, void. The beneficiary had died in March of the previous year. For a second the student didn't move. Then came the first visible crack. His jaw tightened. His eyes flicked, not to the judge, but to the paper. People do that when they already know what's on it, not when they're surprised, when they're measuring how bad it looks. The city solicitor kept going. There had also been a warning. 3 months before the Providence ticket, parking enforcement in Cambridge had stopped the same vehicle for the same placard. No formal charge filed, just a written warning and seizure notice if misuse continued. The notice had been mailed to the registered address on Commonwealth Avenue. Judge Caprio asked, "Is that your address?" The student tried to pivot. "I split time between campus and home." "That wasn't my question." "Yes," he said, "it is." Then the clerk read the final line on the registry record. "Certified delivery received, signature on file." That was the sound you could feel in the room when it happened. Not a gasp, something heavier. The kind of silence that lands when a story stops being an argument and becomes a sequence. Because now his defense was gone. He had not accidentally left an old placard in the car. He had not innocently misunderstood a rule. He had been warned in writing, at his own address, and the state had proof the warning was received. And still, weeks later, he was hanging that placard in a disabled space in another city. That one record changed everything because it established the only thing people like him spend all their energy trying to blur: intent. You could see him realize it. The tone changed first. The sharpness disappeared. Then the shoulders dropped. Then came the familiar emergency retreat into ambiguity. "I don't personally handle family paperwork." Judge Caprio looked at him for a long second. "But you personally hung the placard." No answer. "You personally parked in the space." Silence. "And when asked about it this morning, instead of telling the truth, you threatened the court." The student tried one more move. He said he felt singled out. He said this was becoming disproportionate. He said there were bigger problems in the world than a placard hanging from a mirror. That line did not help him, because the officer who wrote the citation had seen bigger problems too. He was in court that morning, and Caprio allowed the brief testimony. On the night of the ticket, every legal disabled space on that block was full except the one the student took. 10 minutes later, a 68-year-old dialysis patient was dropped off for an appointment nearby and had to be unloaded in the rain half a block away because the closest compliant access point was gone. That was the human cost, not abstract, not procedural, not theoretical, a real person, real weather, real pain, caused by someone who thought rules were for other people. That was when the courtroom's moral center snapped fully into place. The student was no longer a bright young man being judged harshly over a technicality. He was exactly what the record showed: someone willing to misuse a dead relative's disability credentials for convenience, ignore a written warning, and then try to weaponize elite status when called on it. If cases like this make you think, let me know in the comments, because what happened next was as important as the record itself. Judge Caprio was careful, precise. He didn't perform outrage. He didn't need to. He explained the difference between making a mistake and constructing a defense around a lie. He noted the canceled placard, the prior written warning, the confirmed delivery, and the defendant's conduct in open court. He referred the matter for review under the applicable fraud and misuse provision and imposed the maximum financial penalty available to that court on the parking count. He ordered the placard surrendered immediately if it had not already been confiscated. He directed that the hearing transcript and registry record be preserved. Then he said the line that followed the student out of that room and into every consequence that came after. Education is supposed to enlarge character, not decorate entitlement. No one moved. The student looked down for the first time all morning, and that should have been the end of it. It wasn't. Because cases like this rarely stop at the fine once the paper trail is clean. The referral triggered a broader review. Investigators found 2 additional uses of the same placard tied to the same plate in the previous 6 months, one near Back Bay and one in New Haven. Not enough by themselves to make headlines, more than enough to establish habit. His university was notified after the matter entered the formal misconduct channel. A summer internship at a Boston consulting firm quietly disappeared. A character and fitness question that once belonged to some distant future suddenly became immediate. One afternoon of arrogance had reached forward into years he had not yet lived. That is how collapse usually works, not in a cinematic explosion, in a sequence of doors closing. First the courtroom, then the record, then the institution, then the private calls no one hears, then the opportunities that simply do not come back. And what makes stories like this linger is not the size of the original offense. It's the ratio between the offense and the ego that wrapped itself around it. An $85 citation became a reputational wound because he could not tolerate being ordinary for 5 minutes. He needed the judge to know where he went to school. He needed the room to understand that consequences were negotiable around him. He needed authority to blink first. It didn't. And once it didn't, all he had left was the truth he should have started with. Near the end of the hearing, after the ruling, after the referral, after the last attempt at posture had drained out of him, he asked if the court would consider the impact this might have on his future. Judge Caprio's answer was quiet enough that people leaned in. You should have considered that before asking a dead woman's placard to carry your character. That is the part people remember, not because it was cruel, because it was exact. There are people who believe consequences are something that happen to the careless, the poor, the unknown, the people without the right accent or resume or institution behind them. They walk into rooms expecting process to bend. Sometimes it does, and that is exactly why the moments when it doesn't feel so powerful. A courthouse on a rainy morning, a young man who thought prestige could function as pressure, an old judge who had seen too many versions of the same performance to be impressed. And one certified record, plain as concrete, that stripped the story down to what it really was. In the end, he did not lose because the court was dramatic. He lost because the paper was patient. And paper does not care where you studied. If you believe no one is above accountability, remember this one. Because long after the argument faded, long after the coat and the confidence and the practiced voice were gone, what remained was a single page with a state seal on it, and the simple, brutal fact that truth keeps better records than arrogance ever will.